Forget everything you think you know about final wishes. The legal system doesn't care about your dignity. It cares about archaic loopholes and absurd technicalities that turn death into a bureaucratic circus. From inheriting your relative's mountain of debt just by wearing their sweater to courts, validating chicken eggs as legal documents, the world of estate law is absolute madness. Today, we are ranking the 50 most ridiculous, petty, and downright baffling laws that dictate exactly what happens to your soul and your stuff. 1. In France, you legally cannot disinherit your children, no matter how deeply they disappointed you. The French legal system rigorously enforces forced heirship, meaning a massive portion of your estate is absolutely locked down for your offspring by default. Even if your son spent the last 20 years actively ruining your life and forgetting every single birthday, he still gets his mandatory slice of the pie. It is the ultimate governmental safety net for terrible offspring. Makes you wonder, would you treat your parents differently if your inheritance was constitutionally guaranteed regardless of your behavior? 2. There is a bizarre legal loophole called donatio mortis causa, which basically covers panicked deathbed gifts. If a dying relative hands you the keys to their sports car and says it is yours, the law actually bypasses the formal written will and lets you keep it. However, the absolute funniest part of this legal doctrine is that if they miraculously recover and survive, the gift is instantly revoked. You legally have to hand the keys right back to your newly resurrected, highly annoying relative. 3. Courts in the United States routinely uphold wills that force heirs to marry within a specific religion to get their cash. It sounds completely medieval, but it is entirely legal. If a wildly wealthy grandfather states his granddaughter only gets her trust fund if she marries a nice person of his exact faith, the courts will usually back him up. It turns out that controlling your family from beyond the grave is a recognized constitutional right. How much money would it actually take for you to let a ghost pick your spouse? 4. Despite what eccentric billionaires believe, you cannot legally leave a pile of cash directly to your dog. Animals are considered property under the law, and property cannot own other property. You can, however, establish a pet trust and appoint a human trustee to manage the funds. But if you just scribble that you leave $10 million to Mr. Fluffles on a napkin, the legal system will invalidate it, and your greedy cousins will gladly take the dog's fortune while feeding him the absolute cheapest kibble. 5. A Canadian lawyer named Charles Miller famously wrote a valid will, leaving the bulk of his immense fortune to whichever woman in Toronto could birth the most children in the 10 years following his death. This sparked an actual frantic reproductive race known as the Great Stork Derby. Despite furious legal challenges from his outraged relatives claiming the document was immoral, the Canadian Supreme Court upheld the will. 4 women ended up tying with 9 children each, splitting the massive payout. Sometimes, estate law is just competitive extreme sports. 6. If you are planning to record a dramatic video, will where you stare into the camera and dramatically reveal which of your children gets the vintage Ferrari, save your breath. In almost every single jurisdiction, a video recording holds exactly 0 legal weight on its own. Unless it is accompanied by a properly signed and witnessed piece of paper, your cinematic masterpiece is nothing more than a weird home movie. The courts demand ink, not a perfectly lit monologue recorded in portrait mode on your smartphone. 7. The legal system has something called the Slayer Rule, which exists because people actually tried to inherit fortunes from relatives they actively plotted against. Basically, if you are legally responsible for someone's untimely demise, you immediately forfeit any right to their estate. What is truly hilarious about this specific rule is that it had to be explicitly written down. It means a highly paid lawyer once stood in court arguing their very guilty client still deserved the trust fund. 8. You do not always need fancy legal stationery to execute a valid will. In 1948, a farmer named Cecil George Harris was pinned under his tractor in the freezing rain. Knowing he wasn't going to make it, he used his pocket knife to scratch a brief sentence, leaving everything to his wife right into the tractor's fender. The courts legally accepted the piece of machinery as a valid holographic will, and the fender itself was physically removed and filed in the probate records. That is some serious dedication to paperwork. 9. Think you only inherit assets? Think again. Over half of the states in America still have filial responsibility laws on the books. This terrifying legal loophole means that if your aging parents rack up massive nursing home bills and pass away without paying them, the facility can legally sue you to cover the debt. Imagine getting handed a six-figure invoice just for being genetically related to someone with terrible financial planning. If you suddenly get a massive bill for your father's luxury assisted living, would you fight it in court or flee the country? 10. You cannot legally command your executor to destroy your valuable property after you die. If you write a will demanding that your historic mansion be bulldozed or your priceless art collection be set on fire, just because you don't want anyone else to enjoy them, a judge will step in and stop it. Courts consider the wanton destruction of valuable assets to be against public policy. So, if you are planning a final act of extreme pettiness to spite your heirs, the legal system is basically going to tell your ghost to calm down. 11. You might think you can easily leave your spouse with nothing, but the law completely disagrees. In almost every American state, you cannot legally disinherit your husband or wife. Even if your will explicitly states that they get absolutely zero, they can just invoke the elective share law and legally snatch about a third of everything you owned. The government essentially forces you to be financially generous to the person you were trying to legally ghost. Makes you rethink those vows, right? 12. The legal concept of redemption by extinction sounds like a complicated sci-fi movie, but it is actually just a cruel estate rule. If you specifically leave your nephew a vintage Rolex in your will, but accidentally drop it in the ocean before you pass away, your nephew gets absolutely nothing. The law does not give him the cash equivalent. It just shrugs and declares the gift extinct. If your wealthy aunt promised you her antique sports car, you better hope she drives carefully. 13. Imagine a married couple meets an untimely demise at the exact same moment in an accident. Who inherits from whom? The uniform. Simultaneous Death Act steps in with pure legal fiction. It dictates that for the purpose of passing out the cash, each person is legally treated as if they survived the other. It is an incredibly confusing mathematical paradox designed entirely to stop rivaling sets of in-laws from fighting over the insurance money in a bitter court battle. 14. Science has officially outpaced estate law. In several jurisdictions, a child conceived via in vitro fertilization years after their father has passed away can still be considered a legal heir. This completely terrorizes estate planners. Imagine waiting to split a massive family trust, only to find out a brand new infant sibling just dropped out of cryogenic storage to claim their legal share of the estate. How long should an inheritance legally wait for a baby that hasn't even been conceived yet? 15. If you think keeping your beloved grandfather's ashes in a decorative urn on your mantle is a beautiful tribute, German law thinks you are a criminal. Germany has an incredibly strict burial law requiring all human ashes to be buried in an official cemetery. You cannot take them home, you cannot scatter them in a scenic forest, and you certainly cannot press them into a synthetic diamond. The state essentially holds a rigid monopoly on exactly where your relatives are allowed to rest. 16. Here is a bizarre reality about the mechanical parts left inside you. If a deceased relative is being cremated, their pacemaker absolutely must be surgically removed first because the batteries will literally explode inside the incinerator. But instead of throwing them away, a weird legal loophole allows funeral homes to donate these used, second-hand pacemakers to veterinary clinics. Yes, your grandmother's heart monitor could legally end up keeping a stranger's golden retriever alive for another decade. 17. English common law allows for something incredibly sketchy called a half-secret trust. This is when you leave a giant pile of money to a friend in your will, but legally bind them to give it to a secret third person whose identity is never written down anywhere. It is basically the legal equivalent of passing a folded note in a middle school classroom, and it is entirely enforceable by a judge. It is the absolute perfect loophole for secretly funding a hidden second family. 18. You can totally use your will to deliver the ultimate posthumous punchline. The famous 19th century poet Heinrich Heine supposedly left his entire massive estate to his wife on one incredibly strict legal condition: she had to remarry. His written reasoning for this bizarre demand? Because then there will be at least one man to regret my death. It remains the gold standard of using a binding legal document to absolutely roast your spouse from beyond the grave. 19. The rule against perpetuities is a property law so notoriously complicated that law students actively cry over it during their final exams. Basically, it prevents you from controlling your wealth from the grave forever. You cannot legally create a trust that dictates exactly what your descendants must do with your money 500 years from now. The law puts a strict time limit on your posthumous control freak tendencies, eventually demanding that you finally let go of your wallet. 20. When your grandparents pass away, you do not just inherit their physical house, you legally inherit their copyrights. This includes the exclusive rights to every single handwritten letter, diary entry, or terribly written poem they ever produced. If someone finds an old love letter your grandfather wrote and tries to publish it in a historical book, you can legally sue them for copyright infringement. Are there any embarrassing family secrets hidden in your attic that you would actively sue to keep quiet? 21. A wealthy Portuguese aristocrat named Luís Carlos de Noronha Cabral da Câmara created the ultimate chaotic good inheritance. Having few friends and absolutely no heirs, he randomly chose 70 strangers out of a Lisbon telephone directory and left his entire massive estate to them. When he passed away, these utterly confused people were contacted by fancy lawyers and suddenly handed a piece of a massive fortune out of nowhere. It is the ultimate real-life lottery. Would you even believe the phone call if a lawyer said a stranger from the phone book left you millions? 22. Leaving someone completely out of your will can easily backfire because they might claim you simply forgot about them due to failing mental health and aggressively sue your estate. To expertly bypass this, lawyers suggest leaving a wildly insulting token amount, like exactly $1 single. This legally proves you were in your right mind, you remembered they existed, and you purposefully chose to give them essentially nothing. It is the most legally bulletproof and wonderfully petty way to say goodbye to an annoying relative. Imagine their furious face reading that document at the lawyer's office. 23. In the modern era, your physical belongings are completely overshadowed by your messy digital footprint. Most states now have strict laws treating your social media accounts, gaming libraries, and cloud storage as legal property. This means you literally need a formal estate plan for your embarrassing search history and hidden photo albums. If you do not legally appoint a digital executor, tech companies will flat out refuse to let your grieving family access your locked devices. Are you absolutely certain you want your parents legally inheriting unrestricted access to your private cloud storage? 24. Before the historic Apollo 11 moon landing, the famous astronauts realized they could not afford standard life insurance for a wildly dangerous space mission. Instead, they sat down and signed hundreds of postal covers right before launch. If they perished in the vacuum of space, their widows could legally sell these incredibly rare, morbid autographs to fund their lives. It was literally life insurance funded entirely by extreme space memorabilia, proving that sometimes legal loopholes require out-of-this-world thinking. 25. In France, you can legally marry a deceased person, and it fundamentally alters your inheritance rights. Originally popularized during wartime, posthumous marriage is permitted if you can firmly prove to the President of France that you genuinely intended to marry before the tragic death occurred. Once officially approved, the surviving partner is legally declared a widow or widower, allowing them to inherit pensions and estate benefits as a legitimate spouse. You can literally walk down the aisle with a ghost to secure a legally binding financial future. 26. Japan has one of the highest adoption rates in the entire world, but over 90% of those being adopted are fully grown adult men. It is a wildly pragmatic legal workaround to keep family businesses and massive inheritances intact. If a wealthy CEO does not have a suitable male heir to inherit the empire, he simply legally adopts his most competent adult employee or his daughter's husband. The massive estate gracefully transitions to the new son, proving that sometimes blood is entirely secondary to a fantastic corporate resume. 27. A surprisingly common and entirely legal clause in aristocratic estate law is the strict name and arms requirement. Wealthy families desperate to keep their legacy alive will leave massive fortunes to a distant nephew or cousin, but only on the mandatory condition that the heir legally changes their last name to match the deceased. If you refuse the humiliating bureaucratic hassle of altering your driver's license and entire identity, you instantly lose the millions. Would you legally change your entire identity tomorrow if a dead relative promised you a ridiculous mountain of cash? 28. Donating your remains to science sounds incredibly noble, but the law gives you almost zero control over what that actually entails. Your grieving family might assume you will peacefully help medical students learn anatomy in a quiet classroom. Instead, your estate legally surrenders all rights, meaning you could officially be utilized for bizarre experimental robotics testing or highly unusual academic studies. Once you sign that specific paperwork, you become official research property to be used in wildly unpredictable ways. 29. Estate law technically recognizes holographic wills written on almost any conceivable surface as long as the legal intent is crystal clear. In 1925, an English sailor navigating a violent storm wrote his final testament directly onto an empty eggshell. Astonishingly, the probate court officially validated the wildly delicate breakfast item as a legally binding document. It absolutely proves that rigid legal bureaucracy can be surprisingly flexible when faced with extreme survival situations and fragile poultry products. 30. What happens if you completely lack any friends, family, or random phone book strangers to give your money to? Your fortune falls victim to a depressing legal concept called escheat. This ancient law dictates that if a person dies completely, intestate with absolutely zero identifiable heirs, every single penny of their life savings simply reverts back to the government. The state basically shrugs, says thank you for your lifelong hard work, and drops your fortune directly into the public treasury to pave a few random potholes. 31. In many European jurisdictions, the concept of universal succession means you inherit both the massive wealth and the crippling debt of your deceased relatives. If your uncle dies completely broke but leaves behind a cool vintage leather jacket, taking it can legally constitute accepting the entire estate. By simply putting on that old coat, you might accidentally accept legal responsibility for $500,000 in unpaid bank loans. Would you risk total financial ruin just to keep a sentimental family heirloom? 32. German law explicitly recognizes a concept known as the laughing heir. This happens when a completely distant relative who hasn't spoken to the deceased in decades and sheds exactly 0 tears at the funeral unexpectedly inherits a massive fortune. Unlike some jurisdictions that put a cap on how far down the family tree money can travel, Germany lets the cash flow to virtually any blood relative if no closer kin exists. Imagine getting a multi-million-euro phone call about a great uncle you thought was a fictional character, made up by your grandma. 33. People who freeze their bodies in liquid nitrogen face a massive legal hurdle because the law considers them definitively deceased. You cannot legally own property if you are technically a corpse. To get around this, wealthy cryonics enthusiasts use a personal revival trust, leaving their fortune to a legal entity designed to hold the cash for centuries until science thaws them out. Imagine waking up in the year 2500 only to find out your trustee legally embezzled your entire cryogenic retirement fund. 34. If you want to absolutely ruin someone's reputation with outrageous lies, the legal system heavily advises you to simply wait until they pass away. In the United States, a deceased person legally has no reputation to protect, meaning you cannot successfully be sued for defaming a corpse. This is exactly why ruthless biographers wait like vultures for a celebrity to expire before publishing their wildest, unverified rumors. The law basically states that once you stop breathing, Your legacy is completely up for grabs. 35. The brilliant philosopher Jeremy Bentham used estate law to ensure he would never miss a meeting, even after his demise. He legally left his considerable fortune to University College London with one incredibly morbid stipulation. His physical body had to be preserved, dressed in his everyday clothes, and wheeled out to attend all major board meetings. The college legally complied, and his stuffed corpse sat in a wooden cabinet for over a century, occasionally being recorded in the official meeting minutes as present but not voting. 36. A phenomenally petty way to use property law is forcing feuding relatives into a miserable legal partnership. You can purposefully leave a single-family cabin to 3 siblings who absolutely despise each other as tenants in common. Because of how the law structures this shared ownership, they cannot easily sell the property without unanimous agreement or a horribly expensive court battle. You are legally guaranteeing that your squabbling children will be forced to aggressively argue during every single family vacation for the rest of their lives. 37. If you buy a massive, beautiful piece of rural property, you better check the woods for old tombstones. Under the legal doctrine of the cemetery access right, if a family's ancestors are buried on your private land, their descendants possess a legally protected right to cross your property to visit the graves. You cannot build a giant fence to keep them out, and you certainly cannot trespass them. How would you handle a random family legally holding a loud memorial service in your private backyard? 38. Signing an organ donor card feels like an ironclad legal decision, but in many hospitals, your signature is surprisingly weak. Even if your legal driving documents explicitly state your desire to donate, a grieving and fiercely opposed family can often legally veto your choice right at the hospital. Doctors are incredibly hesitant to face a massive public relations nightmare or a lawsuit from an angry widow, so they will frequently defer to the living. Your final, most generous legal wish can absolutely be canceled by an emotional relative. 39. In ancient times, estate laws heavily favored wildly extravagant funerals as a display of immense wealth, leading to the creation of professional mourners. Wealthy citizens would legally stipulate in their wills that a massive chunk of their fortune be spent hiring random women to aggressively weep, shriek, and tear their clothes at the burial. The legal authorities eventually had to step in and aggressively regulate this dramatic fake crying, because funerals were becoming entirely too loud and disruptive to the general public. 40. Your physical remains can legally become extreme novelty items. A highly unusual movement in estate planning involves transforming ashes into playable vinyl records or synthetic diamonds. While it sounds strangely poetic, it creates a bizarre legal nightmare for your heirs. Those custom records and shiny gems are legally classified as standard personal property, meaning your descendants can literally sell your sparkling remains at a common pawn shop if they ever need some quick weekend cash. 41. If tragedy strikes, your grieving spouse might legally demand a doctor extract your DNA to create a future child. In some jurisdictions, if you didn't explicitly sign a refusal before your untimely demise, the surviving partner can get a rapid court order to harvest your genetic material. You might legally become a parent years after your own funeral. Would you explicitly ban your spouse from doing this in your own estate planning, or leave it up to a judge? 42. You can absolutely accidentally ruin your entire family's financial future just by using outdated grammar. For centuries, a terrifyingly complex doctrine called the rule in Shelley's case meant that if a lawyer misplaced a single comma or used the wrong archaic phrasing about heirs, the property automatically transferred to the completely wrong person. It was a massive, chaotic legal trap entirely based on bad punctuation that sparked centuries of bitter, wildly expensive courtroom brawls between wealthy, angry aristocrats. 43. Controlling your relative's physical appearance from the grave is an incredibly valid legal strategy. In the 19th century, a wealthy merchant named Henry Budd famously left his massive estate to his 2 sons on one strictly enforced condition: neither of them could ever grow a mustache. If a single hair sprouted on their upper lips, the massive fortune would instantly vanish. It proves that multi-million-dollar trusts can absolutely be weaponized to enforce your personal, wildly petty grooming standards. 44. If you love your vintage sports car more than your family, you can actually orchestrate a legal burial inside it. While most standard cemeteries will absolutely reject this ridiculous request, private family plots and specialized facilities can legally accommodate it. You just have to completely drain the hazardous fluids, buy a hilariously oversized concrete vault, and hire a heavy crane. Your heirs will stand around an open pit watching millions of dollars of classic automotive machinery be buried forever. 45. Rich people have completely mastered the dark art of the legal disappearing act. If a wealthy businessman despises his current spouse, he can aggressively funnel his fortune into an offshore Cook Islands asset protection trust. When he passes away, the American probate courts will try to award the widow her mandatory legal share. But the offshore trust will simply laugh and refuse to comply. It is a completely legal, incredibly ruthless way to intentionally bankrupt your surviving partner. 46. Getting a massive financial break from a dying relative sounds like an absolute dream. But the government aggressively disagrees. If your wealthy aunt's will officially forgives your $50,000 personal loan, the Internal Revenue Service legally classifies that generous final act as taxable income. You suddenly owe the federal government a massive chunk of cash on money you never actually physically received. Would you be furious if your supposedly generous inheritance just triggered an immediate, devastating tax audit? 47. Cryogenically freezing your entire body is incredibly expensive, so wealthy enthusiasts often opt for a budget-friendly legal alternative known as neuropreservation. You legally instruct the medical team to meticulously preserve only your brain. The law absolutely permits this highly unusual procedure, issuing a standard certificate for your passing while treating your frozen mind as a legally binding scientific donation. It is a wildly complex loophole designed entirely to keep you perfectly chilled for a future century. 48. If your grandfather bought a wildly expensive, completely meaningless feudal title online, you legally have to deal with it. In the United Kingdom, certain archaic titles like Lord of the Manor are considered legally transferable property. You can inherit the fancy piece of paper and absolutely force your credit card company to emboss your new ridiculous aristocratic title on your plastic. You might be completely broke, but the law guarantees your right to sound incredibly pretentious at the grocery store. 49. The person who buys your cemetery plot legally controls the narrative of your entire existence. If your bitter ex-husband purposefully buys the exact piece of dirt you are buried in, he legally holds the exclusive right to dictate exactly what goes on your headstone. Your new family cannot legally alter or remove a wildly insulting, passive-aggressive engraved message without securing an exhausting, expensive court order. The law basically states that whoever holds the receipt gets the final word forever. Okay, we have examined 49 points, and only one final entry remains. But before we move on to number 50, it is time for the final verdict. In our opinion, the award for the absolute dumbest legal rule goes to the strict formatting laws of wills. Simply because a perfectly clear, high-definition video of you stating your final wishes is legally worthless, but if you scribble those same words onto an empty eggshell, a judge will accept it as binding paperwork. It is peak bureaucratic stupidity. Do you agree with our verdict? Let us know in the comments. And now, our final number. 50. In the past, people utilized a terrifying financial tool called a tontine, which was basically a legally binding survival competition for incredibly wealthy investors. A group of rich friends would pool their massive fortunes into one giant fund, and as each member passed away, their share was completely absorbed by the survivors. The absolute last person alive legally claimed the entire massive jackpot. Unsurprisingly, governments finally banned this practice because the extreme conflict of interest was simply too dangerous. The legal realities of passing away are far less about dignity and more about chaotic loopholes, petty revenge, and confusing paperwork. The bureaucratic circus that follows our demise is entirely a human invention. If you were handed a massive inheritance tomorrow with a ridiculously petty condition attached, would you swallow your pride and take the cash? Share your answer below, hit subscribe for more unbelievable history, and always read the fine print before signing anything.